So we keep using these words about consideration needing to be legally sufficient. So the maxim is that consideration needs to be sufficient, but it doesn't need to be adequate. So it goes to this idea that to be sufficient, the promise that you make in exchange for the promise you receive needs to be something that the law regards as valuable. But it doesn't actually need to have equal value to the thing that you're getting. So the key cases here include Nestle and Thomas & Thomas. David Goodwin in his intro video talks about the peppercorn rent in Bermuda. $1 can be enough, provided that it's used in a way to demonstrate that it's being used to substantiate intention. Chappell and Nestle is a good case to have a look at, even though it's an English case, because it sets out the reasons why the wrappers on a chocolate bar could be considered good consideration. But I think the key case for us here is Woolworths and Kelly. So that's supposed to animate, and clearly it doesn't. But basically in that case, Justice Kirby went through the reasons why it is not appropriate for the courts or judges to question the adequacy of consideration. And in my mind, these go back to the very first week that we were together and we started to talk about why do we have contract law at all? And why are the cases so old? And why doesn't it change very dramatically? And they all go to this idea that if business people are going to make business deals, that they will benefit, or a society or an economy will benefit from those business arrangements being dealt with in a consistent way. So Kirby looks at a range of different things. So he says, for example, it's impossible to evaluate the equivalence of promises. And I started to touch on this when we were chatting at the beginning of the class. I don't think it got caught on the recording though. That idea that in almost any commercial transaction, by definition, each party thinks that they got a better deal than the other party. That when I buy a house, I think that house is worth more to me than it's worth to anybody else, most likely, because it's a one-off asset and I've managed to secure it. But also it's worth more to me than keeping that money in the bank. And the person who's selling it, it's worth less to them than the amount of money I'm paying for it. And the same could be said whether we're buying houses, we're buying shares on a stock exchange, or apples at a supermarket. That the choice in anything we purchase is between leaving the money in our pocket and buying the thing. That's why we love a bargain. We feel like we're getting the better deal. So actually it's impossible for a judge to accurately evaluate equivalence. And different people will put different values on different things. Nextly, and it's rare for a judge to say that, this judge said judges and lawyers are not always qualified to opine on the wisdom of a deal. They only have legal expertise. They don't necessarily have commercial expertise. They don't necessarily know what the best part of the deal is. Thirdly, he says, actually, imagine how long the trials would take. It takes long enough now to get a commercial dispute before a court, but imagine how much evidence would be required. All of this would lead to the uncertainty to the enforceability of contracts. If every time commercial people did a deal, they had to turn their minds to what a judge would think of the value of the deal, that would be a very difficult thing. And then lastly, he speaks about or writes about this idea of economic freedom. Parties are free to make their own deals. And that private law idea sits behind a number of what many of you will think are the most unfair elements of contract law as we move further through. Because contract law sits on this, I think, very flawed assumption that the parties have equal bargaining power. I think I've already used this example that Jenny Patterson said to me. She's the author of your textbook. She was a senior banking lawyer at a firm that is now Mallison King & Wood Mallison, sorry. And she said in her entire time that she was working there, the only time a borrower ever brought a loan contract into a meeting was when the borrower was Rio Tinto. So the banks set the terms, right? If you're borrowing money from the bank, you might feel like you're negotiating with your mortgage broker or your bank, but actually they're the ones who are providing the terms. It's structured in a way so you make an offer to borrow money from the bank, but they're the ones who are saying what the terms are. They're the ones with the teams of lawyers behind them. And many people will borrow considerably large amounts of money to buy a house and never get a lawyer to look at their loan document. And why would you? Because actually you can't negotiate it. If they point out a term that you don't like, you can't actually negotiate or change it. They'll just say, no, thank you, we'll lend the money to somebody else. Now, we do have, well, those of you who followed the Royal Commission last year will, have your tongue in your cheek as I say this, but we do have some safeguards with consumer law and banking laws that protect when there's an inequality of bargaining power. But from a private law perspective, from a common law perspective of how contract works, we sit under this flawed assumption that commercial people can do whatever deal they want to do. And that commercial people will agree terms that suit them. And it is not for outsiders to determine whether or not those terms are good or not. Good for whom? But I think it is actually so what Kelly, start again, it's only Monday. What Kirby is saying in Woolworths and Kelly is that it's not the common law's job to address the adequacy of the deal. If the legislature is worried about unfair deals, well, that's their job to fix that. But it is not the job of the common law to do that. Questions, concerns, frustrations?
What if there's two parties and they consider something to be valuable, but it has no value in the eyes of the law, so it might have a sentimental value, and they provide that as their consideration at that given time, say a family member, it's some old garment of grannies or grandpas.
Something that's been in the pool room, shall we say.
Yep, and then, correct, and then later on they say, well, no, actually, forget all that.
So, again, it's a really good set of examples. A lot of these kind of cases come up and they go to intention. Even though we're talking about consideration here, they go to intention because it's when parties are fighting over things that have sentimental value, is usually their family members or their close friends or members of the same cult or members of the same church, members of the same club that authorises you to practice your profession. So they tend to be very personal fights. And the court will look and say, well, what is the consideration here? And usually, for us as lawyers, when it's dubious that it would be something that the law considers has value, then we would be looking to document it in a deed or add in a nominal dollar amount as well. So I got a good question during the break, which is, well, I'm paraphrasing here, but I think the words were, how ridiculous can we go with this? Could consideration be a smile or a wave or something like that? And the short answer is it needs to be something that the court can see has value. So Kim Kardashian, or one of the Kardashians, I can't remember who they are, but I know one of them makes a fortune by smiling on Instagram with a product of somebody's very close by. But it is the combination of the smile, the placement of the product, and the publishing it to the world that is consideration for the dollar value that she receives. If she went into a dark room and just smiled at the Ferrari, I don't think that she could command the same kind of dollar value, and I don't think a court would be happy with that either. So we need some kind of evidence and something that is valuable. The court just won't question how valuable. Okay, past consideration rule. We've talked about, see, this is what I hate about slides. They go in such a straight line and we're talking all over the place. So, an executory contract is where we exchange a promise for a promise. 99% of bilateral or multilateral contracts that you are involved in or you'll see will be executory at the point they are executed. So executed can mean signed, but mostly means a promise for an act. A promise for an act or a forbearance that's already been done. So all unilateral contracts, there is an executory promise and there is an executed promise. Past consideration shouldn't be called consideration at all as far as I'm concerned. It's a promise for something that has been given before the promise is made. So in the quiz example that I had earlier when we talked about Monica's dog, selling Monica's dog to Bill, earlier on that was cigars, but we got too silly. Roscola and Thomas are the same kind of facts. So the promise was made after the deal had been done that the horse wasn't lame. And that promise wasn't an enforceable promise. So there are some exceptions to the idea of past consideration. We spoke about Lampley and Braithwaite the other week. There's also Casey's patent case and the power on case as well. So past consideration can only be good consideration if these three things have happened. Firstly, it's provided at the request of the promisor. The parties understood that the act would be remunerated, and if the promise had occurred in advance of the act, it would have been enforceable. So in Lampley and Braithwaite, the gentleman who gathered horses and went around trying to get the pardon, if the conversation had flown the other way, they would have been fine. And so the court says, well, it was understood all along. So he did the thing, gathering horses, going to inns, lobbying for a pardon at the request of the man sitting in jail. There was an understanding between them that they would be remunerated. And that if the promise to do the thing had happened after the remuneration promise, then we know that it would have been enforceable. So we're effectively ignoring the fact that it wasn't. Pow On and Lao Yu Long is in your textbook. The facts there are a little bit confusing, I think. I wonder if I've got them on a slide separately. Just have a look. No, if I do, it's later on. So in that case, there was a holding company that had a subsidiary company, and the subsidiary company owned a building. And the purchaser was basically buying shares in the subsidiary so that they could take over the building. They'd agreed a price, they were moving things around, and the holding company said to the purchaser, I'm remembering the facts here, trying to simplify them, but the holding company said to the purchaser, look, just hang on for a minute, we don't want to spook other investors. If there are large numbers of shares trading at the moment on the stock exchange, it's going to affect our share price. And so the purchaser said, okay, I'm prepared to hold on for a moment or for a little bit of time, but I need you to guarantee the price. And then a couple of weeks later, so they entered into a deal. Then a couple of weeks later, the stock market was going up and down, and the purchaser realised that they stood to lose a lot of money if the share price waived too dramatically as a consequence of the first deal they'd done. So they went back to the holding company and said, look, we don't want to be out of pocket for this. You've got to guarantee that you've got to make up our losses if there's a shortfall out of this first deal. Anyway, there was a shortfall. They went and sued for the balance. The holding company, Long, basically said, well, there was no consideration for that second promise. You were changing the terms of our first deal. You didn't pay us any consideration. You shouldn't have to do that. And this test comes out of that case. They said it was done. This deal was done at the request of the Promisor, at the request of Long. There was an understanding, in this case, that the person who had been requested to take this action would not be out of pocket. So their remuneration was in effect that by holding on to the shares, they would be paid the balance of any money that they lost. And if they'd done it the other way around, it would have been enforceable. Now, again, we don't want to rely on exceptions in real life. They're good ways of solving problems if we can find them, but we don't set ourselves up to fall within an exception. The lawyers for Powon at that stage should have been getting that amendment to the contract in a deed, because otherwise they'd be making up the difference. The next thing is this existing legal duty rule, which we've spoken about a bit over the course of our travels, but it raises this idea of a promise being illusory. So that's a term that's going to come up a number of times. So in order to be sufficient consideration, consideration can't be illusory. So illusory, we all know what that means, comes from illusion, disappearing act, something that is nothing. And so if a promise is past consideration, it's considered to be illusory because you had to do it anyway. The example, which I think is on the next slide, was Collins and Godfrey, couldn't remember the name of the case earlier, where the promise was to show up under a subpoena. There's no promise there because he already had a duty to do that. Glasbrook Brothers and Glamorgan is an interesting case. In that case, there was a strike in Wales, I think, somewhere. Coal miners' strike, I think it was in Wales or in the south of the UK. And the owners of the mines asked the police to come to keep order so that the people who weren't on strike could get through the picket lines to go and do their work, because the picketing was quite violent and quite distressing. And the police said, well, you know, we've sent a bobby down there, everything's all right. And the mine said, no, we need more enforcements than you would usually send. We need to make sure that we can keep the mine running 24/7, and we need you to basically push these picketers away, so a couple of bobbies isn't going to do the job, and we will pay you the overtime for the additional men. And so the police did that. The strike was eventually resolved. The police sent a bill to the mine, and surprise, surprise, the mine said, no, that's your legal duty. You are police officers. You are here to keep the peace. That is your job to do that. But the court said, well, actually they were doing something that was above and beyond what they'd been asked to do. So there was consideration, the doing something above and beyond what they'd been asked to do in exchange for the promise for the additional payment. So we end up with these two sailor cases here. One day I need to write down which one is which, because I get them mixed up. I think Stilk and Myrick goes first. So Stilk and Myrick is a case that involved some sailors going to CCC to see what they could CCC. They travelled into the middle of the Caribbean or somewhere equally exotic. A couple of them decided to jump ship. They didn't like it. The others were thinking about jumping ship, and the captain said, tell you what, if you help us sail back home, perform your contracts like you should have, we'll share that extra 2 sailors' income with you. They got back to London, surprise, surprise, they didn't share the money, they got sued for it, and the judge said, no harm, no foul, that was your job. You had already signed a contract, agreed to amount of payment. It was your job to come back. There is no consideration for that additional work.
Presumably they were working harder, though, because some of the other sailors had left, so...
Yes, well that brings us to the next case, because the case, I think, in Hartley and Ponsonby, facts are almost identical, except halfway point there's a mutiny, and more than half of the sailors jumped ship. Same deal's done, came back, we get the opposite result. Because in that case, with half of the sailors jumping ship, everybody's doing twice as much work, not 1.01% as much work, or whatever it is that they worked out the number to be. And so there was true consideration in relation to that. So the general rule is that a promise to perform an existing duty is no consideration, at least when the promise is made by a party to a pre-existing contract, when it's made to the promisee under that contract, and it is to do no more than the promisor is bound to under the contract. And this is the key words, to do no more. To do no more. So a little bit more, a little bit of overtime is different from doing the work of 3 men, which is what most women do every day. But
That's
funny because it's true. Sorry, go on. Oh, now you're shy.
it's kind of interesting because even though it's a really, really small amount, it's still of value because so
It is a really small, but it's a really small amount, but it's in the confines of what their promise already was. And again, when you think about it, going to sea, it's quite reasonable to think on any given day somebody's going to be sick or somebody might be injured or whatever. And I can't remember the numbers in a percentage sense, and it's not as easy as that. But when you've got half of the people gone, it's quite different from when you've got a couple gone. And the other thing is, I guess from the lawyer's point of view, easy if you're a lawyer and you know, there are things you can do about it. You could add some fresh consideration in. You could say, all right, like we will do that, but we need some other evidence of consideration for this extra thing. So we'll bring back a bottle of rum. We'll give you a bottle of rum for this, or whatever it happens to be. We also end up with a practical benefit exception. So when we do our shoot on the weekend, I'm going to work through a practical benefit problem. Okay, so we'll go through a problem step by step for those who want to come. We also have the promises to third parties, which I'll get to a separate slide on in a minute, and the idea of a bona fide compromise of a legal claim. So where there is a genuine belief that there is a compromise in place. And of course, you can always terminate your original contract and replace it with a new one. So, are we sick of the rule in Pinnel's case yet? Not everybody's probably spent as much time with it, but those people who did the discussion board task, which was a Pinnel's case task, did a really good job. Overall, they were fabulous. So basically the rule in Pinnel's case says that that part payment of a debt is not good consideration for somebody's promise to waive the other part of the debt. So again, the example is, I owe Scott? Yep. Oh, good. I owe Scott $100. Scott doesn't like me owing him money. I owe it to him today. Like, let's not worry about how I owe it to him or why I owe it to him. I owe him today. I'm not disputing that I owe him the money. I just don't have enough money to pay it. I don't want to pay it. He wants it paid. So he says to me, Kath, if you pay me $80 today, I will forget about the rest of it. So I think, okay, that's fair enough. I can live with that. I'll give him $80 today and get this demon off my back. I do that. The next day he's knocking on my door asking for the other 20. Scott, we had a deal. And he says, well, I've been talking to all of these other people I do contract law with, and they tell me that part payment of a debt is not good consideration for a promise to waive the balance of the debt. And those people are right. So why is that? It comes from the rule in Pinnel's case anyway, but how is it consistent with the other things that we've already learned?
Because you already had an obligation to pay.
I had an existing legal obligation to pay. We hadn't actually sat down and documented a bona fide, like if I'd been disputing the debt and we sat down and we said, even on a without prejudice basis, we agreed that it'd go away, we would resolve our claim for $80, and both of us said without any admissions of guilt we agree that, or we put it in a deed, we would be fine. If, when Scott had said that, if Scott had said, tell you what, Kath, give me a bottle of whiskey and pay me $80. Actually, I'm thinking, no, give me a bottle of whiskey and pay me $20. we'll wipe it off. Would it be enforceable then? Would he be able to come back and be looking for his other $80 then? No, because I've given him something else. So I've paid consideration effectively for the new deal. I've paid consideration for his promise that he's not going to continue to chase me. So it seems confusing. It's actually really quite straightforward. Past consideration is not good consideration. My promise to pay you $100 is not good consideration for the promise back later on for you to relieve me of $20 of that debt. So the actual
before the due date, does that mean that you could pay part of it before the due date?
Yeah, well, that's the other next example. Say that money is due next week. And Scott, I'm sorry, you would not believe how little they pay me to do this job. I do not have $100. Do not have $100. I could possibly, I've got 50 at the moment, that's it. But that's probably going to be spent, quite frankly, by next week. And he was to say, well, if you pay me that $50 now, I won't claim the 100 that you don't owe me until next week. That's good consideration, because he's getting the benefit of early payment. So one of the things that threw a lot of people, well, actually, having said that, one of the things with the Belinda and Bert question that tended to throw people in the past, this group have been pretty good about it. Actually, I only saw a couple of people who only touched on the edge of it, was people were worried, well, what do we know for sure that Bert owes that money to Belinda? Maybe there's no contract there. I think when you get, particularly in an exam question or a short question like that, if you get a statement that says A owes B $100, you can assume that there is a contract and that they owe it right now. If it says A is a party to a contract with B and will need to make a progress payment next week, you can assume that there is a contract. In an exam or in an assignment, you might want to explore a little bit more broadly, particularly if you're getting instructions from somebody who might not know the difference between a general agreement and an enforceable contract. But in those things, you can think about that. And so the trick with answering the Bert and Belinda question was about looking at whether the promise to reduce the debt was actually enforceable or not. So, we've talked about payment by third party. Let's see if we go to this case. So this is the case that I could not remember the name of last night in the tute, or I could kind of remember but think I would say it really badly. So Hirachand Punamchand and Temple. So I will put on the record, it's a 1911 case. So it's not ancient, but I still wonder whether the result and the law might be different if the Indian party was the borrower and Lord Temple was the moneylender. So in this case, Mr. Temple went to India. He had some adventures and he borrowed some money from an Indian moneylender and he didn't pay it back. So the moneylender, doing what moneylenders do, was chasing him for the money. His father then sent a cheque with a letter that said something to the effect of, I'm sending you this money, was less than the total amount owing, in full and final settlement of my son's debt. If you bank this cheque, I am going to treat that as full and final, your acceptance that the matter is settled. Mr. Hirachand Punamchand banked the cheque and then brought an action to recover the difference. He said, Pinnel's case, part payment of a debt is not good consideration for any promise that I may or may not have made in an implied way to reduce the amount of the debt overall. And then the court said, well, no, sorry. Because Mr. Temple didn't pay the money himself, his father did, it would be a fraud on the third party if you didn't keep that promise. That what you are effectively doing here is, by banking the cheque, you are promising the father that you will not take action against the son. Like I said, I have problems with this, the logic behind it, and partly because I think it's a racist decision. But I could be wrong. I can see the logic flow, but it's certainly good law. So again, one of the ways that we deal with these kind of situations is paying the money from a third-party source.
So in birth, I was just going to say that, if you strike a deal and get someone else to pay it for you, you know that it won't come back on you.
Yeah.
So in the example, if Bert didn't pay, if Tom paid, then Bert's all good.
Sorry, I didn't.
If, say now Bert has been in the example.
If somebody else paid for, so if Ernie,
Yeah.
if Ernie had paid instead, he might be better off. But consider the facts. If Bert had just done exactly what Kristen just said, but said, okay, I've struck a deal with Belinda, I've struck my deal here, I know about this case, so I will get Ernie to pay for me. Ernie sends the cheque, Belinda deposits it. Can Belinda go back to Bert?
Yes.
I think she can too. Why?
Because the original one, the cheque was sent with the note saying, if you accept this, you accept it as full and final payment of the offer.
So the promise was being made to the father. So in this case, unless Belinda knows that Ernie is paying and she's effectively promising Ernie that she will not chase Bert, we still don't have the solution.
So I could literally just get my dad to write a note.
This is literally the case where a posh boy's dad wrote a note.
Come on.
Effectively. Good to know. So we'll talk quickly about the practical benefit exception as well, and then I want to do a problem about practical benefit in the tute, because that's what tutes are for. So this is the English case from 1990. So the Williams business was building apartments, and they had a contract that meant that they got a progress payment or an extra payment if they met a deadline. And they subcontracted some carpentry work. Oh, sorry, it's Rothie who had the main contract, and they subcontracted the carpentry work to Williams. So Williams has basically pitched £20,000 to do this carpentry work. Williams fell into some financial difficulties. So Rothie Brothers said, okay, we will pay you an additional £575 for every flat that you get finished on time. And the question then became whether they had to keep that promise or not. So as a matter of general principle, it's an existing legal duty. Williams has a contract to do this work, say it's 10 apartments, I don't know how many there were, for $20,000 by this particular date. But they're in financial difficulty. So again, so what does that mean? Companies have duties to their creditors and to their employers. Directors have duties to ensure that companies that they're directors of can pay their debts as and when they fall due. So when you're looking at the bigger picture as a company director, if they're in a situation where they may not be able to pay their employees, may not be able to pay the superannuation bill, tax bill, their rent, because they've underquoted on this particular project, sometimes it's the lesser of the many evils. So Williams has said, actually, we're going to be better off breaching that contract and having them sue us. It'll still take months to get through the courts and all the rest of it before we have to do anything about it. But we would be better off being sued under that contract than having the whole business go pear-shaped. So they've basically gone to terminate the contract. And the head contractor is saying, hang on a minute, if you do that, I'm going to be in breach under my contract. But not only that, I'm going to miss out on this progress payment. In fact, actually, it's not a progress payment, it's the opposite. They're going to, if they're late, they're going to lose some money. They're going to have money withheld. So basically, the court found in this case that there was a practical benefit to Roffey Brothers in having, in making that additional payment, in having Williams complete the deal. So they found consideration where none would otherwise be. Now, Select Move is authority for the proposition that this does not work in a part payment of a debt situation. Let me give you an Australian example which might even be more useful again. So slightly more recent than Williams and Roffey Brothers. So this is Musumeci and Winnedell. So Musumeci had a fruit and veg market inside a shopping centre. Winnedell owned the shopping centre. And they were the only fruit and veg providers. And then Winnedell leased another shop to another fruit and veg supplier. And so Musumeci is saying, well, hang on a minute, this is not what we signed up for. We signed up to be the only fruit and veg supplier in this particular shopping centre. It's going to affect our prices, it's going to affect what we can charge, it's going to affect who our customers are. Yeah, we don't think this is a good idea. I think we might just pull out and leave. We'll terminate our lease. And Winnedell said, no, hang on a minute, it's not going to be as bad as you think, and it's going to be terrible for us if you leave and the lights are off in that shop. You know, if those of you in real estate, you want to have lots of people in a shopping centre. If there's too many empty shops, people stop going to all of the other shops as well, right? So they said, what we'll do is we'll reduce your rent by a third for a period of time at least. Subsequently, they then claimed this additional amount. They said, no, there's no consideration for the promise to reduce the rent. And again, Justice Santow found that there was a practical benefit to them to keep that promise. He said that they received a practical benefit of maintaining a fully let shopping centre and that their performance must be worth more than any remedy against the beneficiary. So that the benefit of actually continuing with that contract over that period of time was worth more to them than the remedy that they would have got if they had sued Musumeci for leaving early. Sorry, Craig.
Is there practical benefit consideration in this instance?
No, that's a really good question, because the practical benefit is not consideration, it's an exception from the rule that requires consideration. Because there is, so it's actually, that's a really key point to understand, that The exceptions are exceptions from the requirement to have consideration at all. So because there is a practical benefit, we don't need consideration in this particular situation. So read the cases and read what it says in the textbook, and we'll work through a problem in relation to exactly that on Sunday night. More questions?
Isn't that then called the benefit and detriment requirement?
No. Well, the benefit and detriment... Sorry, no, that sounded very abrupt, didn't it? Sorry about that. It's just I like the conversation. So for consideration to be there needs to be a benefit and a detriment. In this particular case, there's already a contract in place. So they've already had an exchange of promises. I will give you this shop. Let you have exclusive use of it for a period of time. In exchange, you'll pay this much rent. Then the circumstances around change. And Musumeci said, I don't want to rent here anymore. This is not good for my business. I'm going to be going downhill. My whole business and the amount of rent I agreed to pay was based on these assumptions that are no longer true. So I'm going to pull out. And Winnedell says, no, don't do that. We'll reduce your rent because it's bad for us if the shopping centre is empty.
So wouldn't that be detriment to Massey, to the fruit man, and benefit to the company rent?
So what's the benefit to Musumeci?
No, he's in detriment because
Okay,
he's
tell me
got
what.
competitors in the same industry, and the owner of the property who's leasing him the shop is benefiting from him staying for a reduced rent.
But he's already got a legal obligation to stay. He's got a 3 or a 5 year lease, so he's supposed to stay. He's just saying, no, I'm going to break my contract. It's not a crime to break a contract. You're breaking a contract. There'll be consequences for doing that. If you sue me, I'll have to pay damages, but otherwise I'm going to be broke. I don't care. In the future, he owns a fruit shop. Chances are he doesn't own anything else. Sue me. Just saying. It's like, am I casting aspersions on a particular industry? But I'm a lawyer. I don't know anything. You can sue me. I haven't owned anything since the 80s, so other than credit card debt. People set up their affairs in particular ways. So he doesn't mind being sued. So effectively, if he wants... So at that point he says, OK, I won't breach my contract. I'll stay here for a reduced rent.
Yeah.
And then, so what is the consideration for the promise to reduce the rent? Now, if he'd got good legal advice, again, fruit shop owner probably didn't get legal advice, but if he had at that stage, we would have put it in a deed of release or a deed of variation for the original contract, because then we've got no argument as to whether we need consideration or not. But they didn't do that. So instead of a deed of variation of the original contract, he's just reduced amount of rent. And then later on, somebody else has come in with Winnedell and said, like, hang on a minute, you're supposed to be paying us $300 a month, and instead you're paying us $200 a month. So where's that other $100? We want that. So the question became, is there consideration for that promise? And ultimately what the law says is, actually, you don't need consideration for that promise because there is a practical benefit to the promisor of the promisee not breaching their original contract. But have a read of the case, because it's tricky, and I think, Craig, I'm really glad you asked that question when you did, because it can slip under the radar that it's an exception from the requirement to have consideration at all. All right, we're at 25 past. Here we are. Next week is week 6, then you will have a break. Assignments are due in on Sunday night for you lovely face-to-face people, and Tuesday night for those of you who are listening in your pyjamas at home online. I am not allowed to give extensions to anybody who asks for them after the due date. So if you are in the terrible situation where you might need some consideration, talk to me before rather than after. Because it's better if we both say no early on than it is, and you know what your position is, than it is for you to be submitting late. Can I say, if you are submitting and something goes wrong, right? Firstly, 11:55 at night on a Sunday night is not the best time to try using Turnitin and submit things for the first time. Just a heads up. If it turns out something's going wrong while you're doing it, take a screenshot. Don't print or fuck around with the metadata in your document. Just keep it there. Email me the next day. I will not be picking up my phone, and we will sort something out if it's a genuine IT problem, right? Because I don't want to sit up at midnight and talk to you. I love you, but not that much. Turn it in. There is an art to it. So one of the things you need to recognise is if you submit early, chances are you will have a lower Turnitin score than if you submit late, because all of you will be using the same words over and over again in this assignment. So just when you get the Turnitin, if it says that you've got 25% or 45% or something, don't panic, have a look at the report and satisfy yourself that you're not copying somebody else first, because it could just be an overlap. They're my just quick tips. I will be heading to Vietnam the day after our next class, so it is really important that you submit as PDFs, because I will be marking on the plane. Nothing like that. Okay. Have a good week, people.